Well, from pandemic disruptions to farm bankruptcy, 2020, as we all recall, was a big year for ag law developments. And now we continue our agricultural law year in review with Roger McEowen with the Washburn University School of Law. He joins us to continue the top 10 list. Thanks for joining us once again, Roger. Coming in at number 7 on the list is the NRCS's final rule on conservation provisions of the 1985 Farm Bill. What are the highlights there?
Yeah, good to be with you, Christina. And sure enough, we're dealing with a major development in 2020 concerning the 1985 Farm Bill conservation provisions. And this is where NRCS came up with a final rule trying to clarify how they delineate or determine and certify wetlands that are located on farmland. And so this kind of ties into that water rule that's been in the news for so many years. This is kind of the behind the curtain poll, if you will, as to how the regulatory agencies are going to implement that. There are some issues, as I see it, with the final rule in terms of how they're delineating and how they come up with what is the best drain condition of land. And I think farmers and ranchers need to be aware of the specifics of those as I detail those in my blog article. But that's a very important rule that's going to affect a lot of farmers and ranchers across the country.
Absolutely. And just as you did with WOTUS, you always give us such valuable information on your website. Let's move on to number 6, the Dormant Commerce Clause. Can you give us a recap, an example?
Yeah, the Dormant Commerce Clause stems from the Commerce Clause that's in the U.S. Constitution. Article 1, Section 8, Clause 3 in the Constitution says Congress has the power to regulate commerce among the states. Now, it doesn't specifically limit a state's power to regulate commerce, but it's long been held by the U.S. Supreme Court as an implicit restraint on state authority. And why is that a big issue for farmers and ranchers? Well, it's a big issue because some states, and particularly California, have enacted rules that are specifying how certain agricultural products are to be raised or grown or produced if they're to be sold in the California market, which is a huge market for agricultural products. And California has done this with eggs, they've done it with pigs and veal calves, and they've done it with hens. So, they're specifying the way these products are to be raised, and particularly in confinement situations, and they're saying if you don't do it that way in your state, then you can't sell in our state. Well, that may or may not be legal, and there was a development in 2020 where a federal court upheld the most recent reiteration of this, California Proposition 12, against a constitutional challenge, but there is still ongoing litigation in another court against Proposition 12.
Wow. What can we expect from the rest of your list briefly? Because we're going to keep going, Roger.
Oh, you want me to spill the beans on what's left? Well, there are things with respect to pesticide drift. Some water issues remain. The DACA opinion by the U.S. Supreme Court is still out there. We may see that come up. Maybe something known as public trust. And then, of course, all the virus-related, not litigation, but legislation in 2020 may show up in the top 5.
Wow. And you mentioned the word litigation as well. That's something we're going to keep very close tabs on going into the new year as well. So lots to keep up on when it comes to ag law developments. Thank you for doing such a good job of keeping us in the loop. Roger McEowen with the Washburn University School of Law. Thank you for joining us.